please. Good morning, dear colleagues. Frankly, this is a question that I would enjoy discussing. We have had quite a lot of positive developments in investor protection in the recent 3 years comparing to what's was happening before. We see certain trend towards increased investor protection. It's another question, or another issue, whether the developments were successful or not, but there have been quite a lot of them covering the dividends procedure, for example. It has been improved. The periods, certain regulatory periods have been decreased. And of course, we have benefited from the introduction of the international accounting standards, disclosures, quite a lot of finer points, and there's been a lot changing in transparency, and over the rather brief period of time, certain issues have been resolved. Finally, we have benefited from the regulation of delisting, and the High Economic Court issued a very important circular interpreting the liability of directors. And finally, the new corporate governance code that prescribes rules of corporate behavior, and it was recommended by the Bank of Russia for others. So there's been a lot of positive developments in terms of investor protection. Also, most of these positive changes, they all happened due to a rather active position of the former securities market regulator, which has been merged with the Bank of Russia now. So the trend overall is positive, and the reform is still ongoing, and corporate investors have been quite enthusiastic. Could you be more specific? Would you want to comment some of the most recent legislative changes in the past 2 to 3 years? What has been the most instrumental in promoting capital markets, more specifically? If I'm to comment on the legislative rules, the most important change that has been quite influential was listing. It used to be quite a challenge for a company to go private, changing their status from public to closely traded, and this decision would be followed by certain movements on behalf of the exchange that led to the loss of liquidity. It was quite important for investors, particularly those who are allowed only to invest in certain categories of securities, and this loss of listing was quite a dramatic change. Another aspect of this issue was that many corporate governance mechanisms in Russia are hinged on the price of trading, and this of course affects the buyout procedures. Previously there was no mechanism protecting investors, but now for delisting decision you need to have 3/4 of votes of shareholders whose shares are traded. Those who were not voting would have to either accept the offer for their buyout or just go along, and this was very positively regarded and considered by the markets. Is there anything that hasn't been covered, that was not properly taken into account? So yes, there are certain issues, quite a few of them, that have not been tackled, and they're nothing new. It is not that we've learned something last night. Let us imagine it's your birthday today and you have one wish. What would you wish? What would I wish? Of course, we something to relate to our discussion. Something, one wish. You have only one wish, and to be honest, I give Denise some time to think, and I want the other panelists to comment, and also the audience here is welcome to express their wish, what they want to see changed. These issues are always on my mind. It's just the thing to decide what is most important. And you have not much time to think, so pick your wish. The most important issue in any regulation, the issue of liability is key. So enforceability is key. The rule may be there, but you need to enforce it. And it is historically the issue and the problem for the Russian markets. The controlling persons would be liable, and there should be certain measures that would stimulate the company to behave. The corporate law seems to be silent on the controlling party in terms of the definition, and so there is no liability that would stick to the specific party. And I'm sure lawyers here would agree that the existing concept in terms of liability created and attached to the controlling party is rather incomplete. So this is something I could wish for. Well, let us hope it will happen at one day or another. Any of you, are there any of you who would want to wish for something else? What about our panelists? Sergei, anything you could suggest? Well, it's not an easy issue. Some issues are so complicated you can't find an easy solution. This was a provocative question. To ensure proper investor protection, you may need to do 100 different things, and if you fail to do one of these 100 issues, you may fail the whole thing. So I have no wish for a birthday. Do we have other wishes here? I respond to your proposal and offer to wish. I think in corporate governance and corporate governance practices, the known issue is that formally rules may not have been violated. But companies resort to various schemes that would allow them to go free of any liability. I wish for some high-blown, high-profile scandal that would show the ways to go, the ways to change the law. It is difficult to add to this, but I could formulate my wish in the following way. from the point of view of law, and this is our discussion, and then more generally for investors, national, domestic investors or international, what they want is stability and predictability of the environment. This is another issue, how we could go about ensuring that. I wanted to follow up on what Alexander said. I want to formulate another wish for Mr. Shvetsov, because he decided against formulating his own wish. I wonder if we could delegate both the wishes. There are quite a lot of cases and gaps that you know there is an exhaustive list, and you know how to construct a scheme that would allow a company not to violate this or other rule formally. But I would wish for more discretion given to regulators that would allow them to pick certain violations that may not be proper violations in the letter of law.
I would say the central bank has enough powers, and putting the cart before the horse may not be a good idea. We don't have this policy sanction for tightening corporate governance. You see, for many decades, wealth was accumulated by the state, as different from Western countries where it was done by private interests. And now, when suddenly Russia was to transition to the market economy, the only kind of investor available was a foreign investor. And the privatization, as it occurred in Russia, was the only way to counter the influence of foreign investors, but this was too little and not enough. Russia has not enough free capital, and we face strong capital outflows for a number of reasons that we're aware of. Still, Russia lacks internal capital, domestic capital. So improving and protecting the investor would just bring in more foreign investors into Russia. And this is the big issue that the Russian market faces today. Mechanisms indeed need to be created. There is no argument against that. But you can't expect them to start working in the short term. Maybe in the long term, maybe 50 years from now, we'll see a change in the situation. So today, the way this country is run is through state property, through state involvement in large and medium-sized companies, a few hundred or a few thousand of them. Privatizing them is pretty hard because they are not attractive as targets for investment for private investors. When you ask for more powers for the central bank, this wouldn't work, because the central bank is not a body to express political will. It has some powers, but the impetus is to come from the state. And if the state today doesn't see the capital market as a key to economic growth in the country, then there'll be a conflict, there'll be a disproportion. Without the political will behind it, no amount of discretionary powers of the central bank can help. There is something I wanted to say. Alexander said he wanted a scandal, a big case. Well, I think I will make a wish after all. You know, there's a saying that the smart person learns from somebody else's mistakes. The stupid person learns from their own mistakes, and the Russian Federation doesn't learn at all. The Sarbanes-Oxley Act in America was the kind of case that Alexander seems to wish for. You know, the Enron was window dressing. It wasn't even that money was stolen. It was just that the earnings of one period were carried over to a different period, and somebody got a lot of money. But this resulted in this act, which is now 10 years old, and a Wall Street manager said that it was only after a few years since that act that everybody understood that this act saved the American capital market. So my wish would be that Russia may start to learn at least from other people's mistakes, and we have a lot to learn. We have plenty of experience in bankruptcy and sanation of big, large banks for accounts manipulation, but there is no liability of top managers for that. You know, between the Enron case and the Sarbanes-Oxley Act, just a few months passed, and a grace period was introduced for public companies to revise their accounts and to have chief financial officers sign the reporting. And today, the accounts and financial statements of public American companies are trustworthy. If we start to learn from other people's mistakes, or better still our own, then we will move forward. So you can't make a second wish, Alexander? Or, well, I'll be happy with one realized. You said that you had the most pleasant question to answer. I have an unpleasant question now about striking the right balance, and I used the metaphor of a child. Alexander said that the Russian market is rather like a child still growing. So how do you strike this balance between protecting the investor and not over-regulating the market, making market players both comfortable in their security and flexible enough? Investors are people who don't like to be brought within certain limits. How do you find this golden mean? Sergei said my questions may be provoking and there may be no right answer to this question, but we need to address this issue in this discussion if we are to be useful at all. Thank you. Indeed, it was a rhetorical question, a question with no straightforward answer. And each country will have to find its own answer. But let me go back to what I began with. I think there is a founding principle that's important for investors operating in this country or considering that those who are prepared to be involved in investment projects. What they want is transparency and long-term stability of their investment. Secondly, it's about liability within corporate procedures and the effectiveness of those liability rules. I'm a lawyer by education. I got my degree from St. Petersburg University here. So, and I learned early on that the key thing is that punishment is to be inevitable, and that's what makes it effective. I like your allegory of the child's upbringing. Investors, we might say, are creative and they are capricious, but you must set some sort of boundaries, some sort of limits. And it's up to the regulator to set these limits. Over-regulation is never a good idea, and life is always richer and more versatile than any regulation. So we can look at regulation as we have it now and consider why it is not such that it makes the Russian market attractive, either to domestic or to foreign investors. Today we hear all this talk about de-offshorization, but still many agreements are made under law different than Russian law. Why is that so? Because Russian law is not quite as flexible as Anglo-Saxon law or some other jurisdictions. We have just to look at the shareholders' agreements to see that. We perhaps need more discretionary norms where shareholders and investors could have a more flexible form of agreement with due legal protection. And this would make the situation more predictable and more stable in the capital markets and in the investment procedures. A number of domestic Russian companies in the fuel sector are a case in point. These companies invest billions in the national economy, and after a while the state changes the rules of the game. And the economic logic that had driven the investment is suddenly changed, unpredictably changed. And any economic models that investors may have been building for a few decades into the future are just shattered. How can we expect investors to come in droves if we act like that? So this golden mean principle is very necessary. Too much regulation is something that makes the investment climate less attractive to anyone who might be considering investment in this country. On the other hand, we have a lot of regulation already in place, which must be revised, and all the rudiments, the dead letter of the law, are to be cleared away. Denis, if we could follow up on that, would you describe Russian regulation in the capital markets as excessive or as insufficient? And what's the trend? There are plenty of studies performed by a number of analysts, and often market players speak about too much regulation as a major risk in the Russian market or a deterrent to their activity. How would you describe the situation? I know it's always a personal opinion, but what is your personal opinion here? This is a sort of question that has no easy and straightforward answer. It's neither too much regulation or too little. It's a mixture of both. In some areas, there is too much regulation. Still, the goal is not achieved. For instance, if we talk about the corporate regulation, it's this reporting of issues that has to be repeated every quarter, but investors don't see necessary information there. So a lot of work is being done, but transparency is not achieved. And similar situations can be observed elsewhere. My colleague now mentioned the shareholders agreement, an instrument that doesn't work very well under the Russian law. But now that their civil law is reformed to be enforced on the 1st of September, we expect to see some change for the better there. And these instruments should act towards better legal protection of investors. On the other hand, as the civil code introduced the non-public share joint stock company, when this was first developed, it was expected that more discretionary regulation would be introduced, but with, on the other hand, more liabilities for the of the controlling party, so that an instrument of liability could be used against abusers. So the first half of this was realized, but the second was not. And it's like this on each specific point within this remit. And I do agree that striking the balance is hard but very necessary. Well, I intend to be perhaps even more provocative than I am allowed to, but I want to readdress this question to the other panelists. So is the Russian market over-regulated or under-regulated? Perhaps there is nothing more to discuss here. Well, my answer will be far from straightforward. Russia is part of the global capitals market. In some years ago, Russia disbanded its foreign exchange regulation, and the Chinese wall came down. So we're now part of the global financial process. We are in competition with other financial centers in the world. So regulation cannot be static anymore. We have to look to how we act and what we can do to make investors attracted to our economy. Today, Russia doesn't look too bad on that count. I can't say we are losing in this competition. The picture is not quite so bleak, but the market is changing, and it will be, and so will regulation. And it will be done quickly and radically. And we need to improve the quality and volume of investor protection if tomorrow and the day after tomorrow Russia is to be a competitive jurisdiction. Let me give you a simple example to illustrate that. Each financial center has its own strong point. In London, it's the flexibility of the legislation which generates a wide range of instruments. In Singapore, it's the dependability of the instruments. Either model has its strong and weaker sides. Both financial centers are quite successful globally. Now, which way should Russia go? I think we should go more towards the Singapore experience than London. So when I hear calls for more flexibility, for introducing Anglo-Saxon law in the Crimea and so on, I can't agree with that. In Russia, the stock exchange is a dominant player in the stock market because they operate with standard products, both in microfinancing and insurance and operations with stocks. So stability and product standardization are the way to go for Russia, I believe. So I would say we have legislation which is not bad, but it's going to change in the future.
I tend to agree with the statement that regulation is an important tool of competition in this global competition, and Singapore is often quoted as the positive practice, but also I want to add that there's another important competitive tool is law enforcement of regulatory processes, and whether we have a lot or too little regulation, we seem to have areas where we have over-regulation. So there's no one straightforward answer as to whether we have excessive regulation or not. Take, for example, investor mobilization and attraction. Of course, most of our capitals in our markets are foreign capitals, and it's nothing specifically unique to Russia. Other markets have the same kind of process, but we might want to make our rules for exits probably slightly stricter. Our foreign exchange regulation is almost absent. Take, for example, Brazil or China. Ruble is, in that extent, is quite open. But for entering the markets, we need to think of something else. We might want to consider some sort of private fencing. You know that sometimes it's difficult to climb over the bushes than to climb over a fence. But, for example, if you need to do certain applications, you need to rely only on Russian, for example. Or take, for example, the corporate seal. In foreign markets, this is something that has never been used anymore. Or apostilles and other things. This is a sort of a private fence which keeps growing and making entry more and more difficult. So we could talk about law enforcement by the judiciary, by regulators, certain formalities, but these were only some of the examples I could refer you to. So it's not about over or under regulation. Our laws are quite in line with the standards of the emerging markets, but the issue of enforcement or even target orientation, we need to remember that investors are good guys. They should be helped, and investors, whether they're foreign or formally Russian, but coming back with their capitals, they are the ones who would formulate this what is needed, and people who have the wealth to contribute to invest in other businesses. If they needed to, they should be protected and helped. So thank you very much. To follow up on what we have just heard and what Sergei said some minutes ago about the place of the exchange in the capital markets, it seems to be one of the key link in the chain connecting investors and issuers. And in terms of a corporate government, what has the exchange been doing on that front? What will be the most immediate developments? What have you been doing to protect investors? Thank you very much. for the exchange, protecting investors' rights is not a political mission or an instruction. The exchange is benefiting from the transparency and openness. The more investors we have, the bigger volume of transactions, the more listed companies we have, and the more profits the exchange will get. On one hand, the exchange can promote better protection for investors, but we also sponsor quite a few initiatives. We're well positioned to do that from the point of view of law and regulations. To answer your question, if we are to discuss investor protection, against whom are we to protect investors? Unless we know, it is difficult to agree how we protect. What is so specific to Russia, in contrast to other countries in terms of corporate governance? Here, investors should be protected from other investors, in most cases, and not from the majority investors that dictate a lot to the company on the dividends, on delisting, on the buyout, on restructuring, when most of the assets can be stripped out of the publicly traded company, and so on and so forth. So we could go on talking about it forever. And we have heard about the corporate governance codes and listing and delisting regulation here. In my opinion, this corporate governance code, in terms of its status, should be viewed as an instruction how to get a carrot instead of a stick. This is just recommended best practices suggesting where the companies should be moving, while listing is another level. This is more of a stick than a carrot, and it's one of the realistic tools that could affect corporate behavior. This is not hard law, of course. Companies are not forced to become public, and companies are not forced to strive for the highest level of listing. But publicity is is filtering down from the highest level of listing, because this is the top quality of in terms of investors. We have some new rules of listing now, and we've introduced quite a lot of innovations there to protect minorities. New regulations pertaining to refloats, committees that are to be established in the corporate institutions to get to the highest level of listing and to benefit most from the exchange trading. The companies should strive and make a meaningful decision whether they want to get because some of the companies won't go public without their understanding that this may be for a long time to go, and there's specific, very important difference between debt and equity. Debt will be repaid, and creditors will just want to follow up on the company as long as they have the loan outstanding. But investors is a different kettle of fish. They insist on certain issues relating to reporting and corporate governance, and not all of the companies have been fully prepared to honor these obligations after their IPOs. Now they have to deal with rather persistent investors. Now that corporate governance standards, best practices, they could filter into the law. Law is to follow listing, and the code of corporate governance is a collection of the best practices. But of course, we also have to protect investors from some of minorities as well, and also intermediaries, capital market intermediaries may be some sources of pressure for investors. They may go bust. Of course, investors are following reporting from Gazprom or Sberbank, but investors tend not to think, particularly if they are retail investors, how they got into that story of investing. Local retail investors are not well educated. In foreign markets, retail investors are usually represented by various hedge funds, investment funds, mutual funds. In this country, investors are supposed to be very well educated in their decision making. Brokers will be using the money and will act as proxies in voting. Some of retail investors are unaware what they sign up to when they sign their proxy agreements. And what we need to have in place is what we call segregation of accounts, whereby the customers, the intermediaries and funds would be segregated from retail investors in case of their insolvency or bad faith. Retail investors should not suffer. Sometimes we need to think about that. On the 9th of June, we've introduced some of these rules on the foreign exchange markets, and we've introduced a grace period for other markets to do the same. And then there is another issue which is called portability, where you would be allowed to migrate from one intermediary to another. You need, of course, the consent of the other brokers to accept a new client. And of course, this is not just easy migration from intermediary number 1 to intermediary number 2. In cases where this intermediary number 1 is suffering certain negative effects. But this is also about protecting investors. And another important thing to protect them would be to establish central depository that would protect investors from dozens and hundreds of registrars that tended to be affiliated with the issues. And it was rather difficult for the investor to get proof of their interest. Sometimes you also have to protect investors from the government. Thank you very much. Sergei, if we take investors as a target of protection, and in cases of violation, are there any indemnity provisions, any ways for investors to get remedies against professional members of the market, banks, funds? Can you give us some specific examples from the banking sphere? In the banking sector, we all know there is the deposit protection scheme, the deposit insurance scheme, which has been one of the most successful projects in the history ever, which improved the situation in the banking sector overall, increased the amount of retail investments available to the banks. The scheme has been quite successful, and we're talking here about 2 weeks' time, I think, for the physical entities, that for the individuals. to be repaid fully as to their deposits. 700,000 is a significant amount for Russians domestically. That eliminates the risk and shifts it to the collective vehicle. There's yet another important instrument, which is the Fund for the Protection of Investors, which was established as a response to the Ponzi scheme of MMM, and it has been there to help those who suffered from Ponzi schemes and financial pyramids. This is a scheme that would treat the allergy that individual investors may have if they have suffered, and allows them to continue investing if they feel like that. So there's yet another effective instrument, which is the third-party liability insurance for car drivers. And again, it takes a collective liability of insurance companies. They pay up to 3% of their premiums, and then they pay they make payouts from these funds. There are some other tools offered to investors, for example, those who contributed to participated in construction projects, and they can be indemnified should there be any issues, problems with the building companies. It's again a response to what we had back in 1998, where there was a deadlock on the real estate market due to the crisis. There was no sufficient money to continue with construction projects, and many investors suffered. Is there anything else in the pipeline? We intend to guarantee the bulk of pension accumulations. The employers contribute their parts of the pension money, and most of that money will be insured and guaranteed by collective insurance vehicle. This is just the first step. It may be it may have certain liability limit introduced, like in Kazakhstan, for example, which is based on certain level of inflation. We also need to have certain measures to protect investors against insider dealings or manipulation on the markets, and the sanctions or actions that have been provided for in these cases by the legislator in accordance with the international experience have not been working properly. The upside of the better faith deal is much higher than the downside, which is basically the sanctions that could be imposed by the regulator to balance the situation. Elsewhere in the world, we have this kind of a plea with the regulator, whereby the guilty party will be fined for billions of dollars, and the money will be used to indemnify and remedy the parties that suffered. The liability works at the moment as well, but it is the government that compensates the affected parties. We will be introducing a different mechanism where the money will be coming from the guilty parties. Of course, we will need certain changes in the law, and certain efforts should be made towards this, but it appears that manipulation exception cases, when this sort of tool is enforceable, limited to very few, and the companies are aware that their bad faith behavior could be very painful. And there is yet another thing that we want to introduce is the mandatory requirement to buy out shares or debts if there was some case of misleading during the process of going public that would make investors more liable on the other hand, and on the other hand investors will be better advised. There will be fewer cases of misleading, and it will be a better protection offered to investors. Investors will be protected and guaranteed against certain risks that were beyond his control. This last comment may be of particular relevance because in terms of protection, we could argue we need to improve tools that would make compensations better. We could protect investors against moral hazards, although investors, of course, risk when they invest. They need to be in good health and full capacity. We've already mentioned the need of a golden mean, and under-regulation and over-regulation should be balanced. Where is the golden mean in terms of protection, the degree of protection? We don't want to create additional risks for the capital markets if this halo of protection will be provoking more and more risks. If we want to introduce more and more classes of investors onto the investment markets, they may not be properly educated, although some professional investors act rather risky.
Well, we learn from practice, don't we all? I think the right balance would make it possible for investors to earn money and for issuers to attract investment. Certainly we're far from this balance point at present, and it's not that it is skewed, it's that there is a gap. This gap means that both the investors are unhappy and the issuers are unhappy. And regulation needs to not just find the right balance, but to reduce this gap. Now, what I mean by this is this. Investors have to undertake and bear risks, but this is not a casino gambling sort of situation. It's not about being lucky. Risks are to be taken on with the understanding of how much risk you take and what their nature is. Before the central depository was established, investors didn't want to buy Russian shares. They wanted to buy depository notes because they were not prepared to play this Russian roulette of these shares simply disappearing into thin air. So the risks that investors encounter in the Russian market must be reduced by removing some of the risks that investors are simply not prepared to undertake. And the cost of doing that is not too high, as with this depository facility, which helped a lot. It's not about shifting risks onto the state or onto some collective responsibility. It's just building the reasonable mechanisms of disclosure and other processes. What risks must investors be prepared to undertake? Well, one is the management risks of a company. So the investor must understand the industry, the management, the principles of management of a particular company. Non-institutional investors are typically not involved in corporate markets. It's to be done through funds, mutual funds and other kinds. And soon we'll have the system of accounts when private individuals could operate on their own, but relying upon financial consultants. Because, you know, if you are just a regular private individual, you just live your life. You watch football, you take a job, and you spend time with your family. It's not your business to know why one share is better than another share. What such a private individual wants is to be able to use standard products and be comfortable in that they will receive a return on their investment. Today, when there is this gap which makes both the issuers and the investors unhappy, it means we must close this gap. Certainly, you couldn't argue with that. I want to open the floor for comments and questions. Be sure you speak into the microphone. Good morning. I'm Alexander Smirnov of Moscow Stock Exchange. To make our discussion more interactive, I'd like to make a comment. What Alexander and Kirill said is very close to my sphere of interests, and it is stability or predictability. Whether it is the stability and predictability of legal regulation or investor behavior. This is a legal forum, so I'll share with you three legal sphere examples. One is a change in the civil code of Russia. Lawyers will remember that in 2008 the concept for reforming civil law was proposed. It was widely discussed by leading authorities, theorists and practitioners, and a number of amendments were introduced in the civil code that were submitted to the State Duma by President Medvedev during the last month of his presidency. This package of amendments was not perfect, but it formed a single whole. It was adopted on the first reading very quickly, but in the second and third reading, it was split into 9 separate laws unconnected with one another that are being slowly adopted by the Duma right now, piecemeal. That's unpredictability on my books. A second example is about the freedom of contract in the Russian Federation. Over the 20 years of the civil code's operation in Russia, lawyers have come to understand corporate law as imperative law, an archaic situation not found elsewhere in the world, but Russia has a history of law functioning like that, and so this is something inherited from Soviet times. So everyone was accustomed to this idea, and all the lawyers advised their clients about how this norm was immutable for all practical purposes. Professor Vietriansky calculated that there are 650 imperative norms in the law and just 200 or more discretionary. And here we see the law on the freedom of contract law, which says that it's up to the courts to decide whether or not a norm is discretionary or imperative. And it can work both ways. This is unpredictability and instability. Now, the third thing is the merger of the two court systems, the Supreme Court and the Commercial Court of the Supreme Commercial Court of Russia. So all the good experience that was accumulated by this second court of the past 5 years or so is going to disappear in this merger. This was just a comment to illustrate what colleagues were saying. Make sure you are present in the Gazprom business breakfast tomorrow, and you will hear people speak about similar things. Our colleagues from the legal department of Gazpombank are present here, and you should contact them. Do you have other questions or comments, please? Good morning, colleagues. I'm Denis Ryczkov of Orsk Capital. My question is for Sergei and for other colleagues who are connected with the financial markets. To be sure, effective protection of investors I mean, protecting unprofessional investors from professional market players is what we all would like to see. But I'd like to share my personal experiences. The markets have a lot of negative information circulating concerning the bigger investment companies that shall remain unnamed. There are rumors about licenses that can be revoked of some major investment companies. We have heard about Maxwell Capital and Bank and the complaints and grievances about that. The market seems to believe it's connected with market manipulation, and our contacts with the Bank of Russia are affected like this today. If it's if you can do it under law 115, you can do it under manipulation law. So I have this question. Do you see a risk in the present infrastructure for investors? Do you see the risks there, such as I described them, that might materialize in the future? About Bank, the license was not revoked. It's like this. The role of the state here is to provide both competition and protection to private property. You know, these are the two pillars of what we do. But we are to protect not just any kind of competition, but fair competition. Cutting regulatory costs on the way, because if one player operates in accordance with the legislation and incurs costs in doing that, doing everything right, including paying for software licenses and keeping up our internal controls, etc. And another market player is not doing that, this is unfair. This gives an unfair advantage to the second one. This makes the services the second player offers cheaper, and maybe some of the services they offer can be not quite legal, but they will win a larger market share unless the regulator intervenes. The regulators must make sure they stop and cut short the practices that make competition unfair. When we hear about the central bank investigating manipulation cases and insider operations cases, we should not confuse the two. Typically, it takes 18 to 20 months to study one case of manipulation, the insider operations, because it typically involves receiving information from international counterparties, etc. It takes time. And that is why today we are operating on the basis of information of, say, 2 years back, when there was no criminal liability for such activities. We publish the results of our work. We take supervisory measures, such as revoking certificates of parties involved. We don't yet have in place the mechanism of deals with regulators, but this is a special line of business with us. There is a department that is doing just that. Now, about the rumors, I'm not going to comment on rumors, because firstly, it's the first time I hear them, and secondly, they're rumors, period. However, no company can feel it's protected from any sort of influence from the regulator if it's breaking the law. No company is quite immune. If the situation can be improved, we go that way rather than revoking licenses on the first step. But risks of this kind are real. They will remain so. It's like Mr. Afanasyev said a few minutes ago. We are going to protect the investor from bankruptcy of both the broker and the clearing mediator. And if the investor doesn't want to bear this sort of risks, they can bear these risks with relation to the stock exchange. It will be not the 4 eyes principle, but the 24 eyes principles, if you take into account the role of the central bank. Half the central bank is involved in this type of activities, if you ask me. So we are trying to build a system where, without increasing investor risks, we are leveling out the competition playing field for all the participants. And this is a way to provide fair competition for all the participants with identical licenses. I suppose this was a general question. Maybe somebody else would like to add something. If not, and if we have no more questions, then we might continue. Well, if I were to speak from on behalf of the stock exchange, Sergei said something quite reasonably a few minutes ago. When the central bank was merged with the financial market regulator, we received a mega regulator. Then the Moscow Stock Exchange must be regarded as a mega regulated entity. So supervision is pretty strong over us. But this also means that we have our responsibilities too. Each case of suspected manipulation is investigated first internally, and if foul play is found, then it is reverted to the Bank of Russia. On a weekly basis, we start a dozen such cases typically, but very few of them reach the Bank of Russia. News and rumors can escape, can appear on the basis of that, but this is just all in our day's work.
Thank you. Going back to our discussion, question to you, Kirill. Could we go back to the issue of foreign investors and foreign platforms? We have heard comments whether we need to level the playing ground all over so that there will be one playing field in terms of law regulation. Can you unify or make the same rules and standards applicable to all investors and players? The first question is whether it is reasonable at all, and it's my question to your question. Why do we want to do that? Whether it is possible to do that, I think yes. If we could replicate that within some narrow segment in domestically, but there are different classes of borrowers, for example, on the one hand, and also in Russia, corporate standards or standards underpinning the architecture of legal entities. That's we could treat as borrowers are still already there, and whether it can be harmonized with foreign platforms. This is something we haven't yet achieved. We're just moving generally in that direction, and it's another question how far we could go to remove all barriers, all national barriers, and it will take a lot of time, I'm sure. And some of the latest changes in the civil codes that describe public and private companies. This underpins this issue of terminology, harmonization of terms and notions, and this could be one of the important steps forwards for capital markets overall. But another side of this question is what are the benefits? For us, if this country will become better positioned in mobilizing foreign capital, this is one side of the question. But if these standards would be there to benefit foreign investors, make them understand our economy, our capital markets better, is still another side of the question. But overall, I would argue that today, globally, in terms of corporate life, there's a trend towards standardization of processes, so it makes much reason to argue that some of these processes developments are happening, if not at the same time, they're going there. And standardization happens in different sectors of the economy, and of course this is also true of the capital markets and the banking sector. They're moving that in that direction. But if you take the issues of harmonization in, say, energy sector or commodity markets, it took them years and years to arrive where they are. For example, in chemistry, there are certain international regulations and standards that have a global significance, and Russia joined them just a year ago, although the standards and rules have been there for quite a few years, if not decades. So the standardization is a must, but it's another issue how we want to proceed, where we focus our efforts. The process is ongoing, and the G20 countries have been involved in introducing certain standards in regulation all across their group of countries to achieve there are no exemptions. It's another issue that our corporate governance code that was prepared relying on the OECD best practices. Its implementation is a step towards standardization of corporate behavior. Standardization means less cost. If you're outside standards, you run into additional costs. So we need standards to cut costs in involving new players on the markets. And finally, even accounting, the IAS standards, for example, is all about standards. A standards understanding by investors who would be allowed to compare, say, Brazilian companies and Russian companies. This process is global and underway. Basel III implementation will be making the global banking system regulated to certain standards. By 2019, certain uniform and solvency standards will be introduced, and we will accept them. There are certain trends towards regulation of our central counterparts. If we want our system to be recognized by other regulators, we need to adhere to certain standards, and there may be other examples. So we need to be very supportive of harmonization, self-regulation, which we are promoting through law, trying to implement it all across the market. And one of the purposes of this new concept is to promote certain standards of behavior, because one of the same projects with different names could be launched differently, but investors should be allowed to select the best offer. Failing that, the capital markets has failed in its function. So in regulating professional members of the markets in their offers is one of the standards we need to implement. One of the missions of the government in capital markets is to make companies more active on the domestic market. Yandex has recently listed themselves on the domestic market, but the majority of companies still want to be listed internationally in a attempt, in a strive to mobilize foreign capitals. Could you please comment what sort of steps are taking to make our markets more competitive, and what are the concerns that foreign investors have? Is it the infrastructure, enforcement, regulation, Russian language, corporate things that you've mentioned? What are the key concerns? Thank you very much for your very good question. I would like to rephrase it. It's not that companies want to attract their money from other exchanges. There are about 40 corporates that are Russian equity companies. They have Russian capitals, but they have been registered in other countries. This is a business model that has been produced over years, and it's not doesn't make sense to change this model. But about a dozen companies with double listing, both at the Moscow Exchange and abroad. We also have about 300 companies that have only a Moscow Exchange listing. Out of these 300 odd companies, not all of them are blue chips, but still, we have this idea where we need to follow the market where investors are, but this is no longer so. It has been years and years ago. The market has become global since it's not important, this location of the investors. Some 10, 12 years ago, about 20 Brazilian equities were traded in São Paulo. The rest was all over the world. But they then introduced certain reforms, and now the ratios changed to the reverse. It's 80% in São Paulo and 20% in New York. And it doesn't matter much. There's a certain global standard where this difference is no longer important. The difference is important where the standards are lacking, as it was the case in Russia some 4 years ago. We were talking about infrastructure laws, there's the central depository, the central counterparty notion, and the third important move was opening up our market to Euro clearing and Eurostream, and finally introducing harmonized procedures, T+2 settlements. This may seem a technical issue, but it is very important. We've just discussed standards, and if the back office needs to have a separate instruction for Moscow trading, this makes this trading more expensive. And after the 2008 crisis, financial institutions are still looking for points of growth. So they need to cut costs, and they can achieve that by implementing standards. Moscow is now in compliance with most of these technical standards, so this issue is no longer material, and we see our volumes growing. The regional equities are traded more and more compared to depository receipts. Equities, of course, come with many more rights than just depository receipts. We no longer compete with London in terms of exchange process. We compete in equities versus depository receipts. So receipts are limited to a situation where risks are unacceptable, whereby investors don't want even to talk about due diligence. But you need to look for some country where there could be an acceptable market risk, but the investors don't want to go there. This is where this situation emerges. But this time is over for Russia and for many other countries. Take, for example, in the early 80s, Mexican depository receipts were traded, Spanish depository receipts were traded in London, but now all equities are traded in Madrid. So the interest in terms of ADRs emerges only in a certain kind of environment whereby internal regulation is lagging behind the outsider interest in the markets. People say that London is a financial center and everyone wants to be traded at the London Stock Exchange. It's true. London is an important financial institution because of the presence of investors, analysts, and funds, but not from the point of view of trading at the London Stock Exchange. Only 15% of their volumes cover the RUB, and out of these 15%, 96% are Russian ADRs. So basically, this international aspect of the London exchange is Russian money. It used to be Spanish equities or Mexican. Tomorrow it could be Vietnamese or Korean equities. So this is a temporary fact, but we need to work to decrease it. We can do it through reforms, through marketing and investor awareness, and of course with everything else that we touched, including corporate sales and language allowed for various applications and papers. But most importantly, we need to tell ourselves that we want this market not for foreigners, not for the foreign investors' sake, because domestic investor wants the same thing. They want transparency, they want their rights to be protected, they want to have laws predictable. And corporate sale and the language may be at the moment the only thing that is different from other things in other markets. Today, Russian equities can be traded through Cyprus. So we are now talking not about residents, non-residents. We talk about Russian foreigners and foreign Russians, where a non-resident is relying on Cyprus accounts. We have suspicions that this specific investor may be very proficient in Russian, and when a Russian bank subsidiary brings their order to the exchange, we appreciate that this subsidiary is backed by a major entity in some foreign jurisdiction. So sometimes it's very difficult to differentiate between resident and non-resident money. This is a lot of confusion, and we want to make our markets better, not for the foreigners' sake, but for investors' sake, which are both foreign and domestic, to make capitals cheaper, irrespective of the target investor. Thank you very much. It was very passionate, and I think it almost deserves applause. Do we have any further questions and comments from the audience? Thank you. My name is Yerlan Kasimov. I'm a public representative of the Agency of Strategic Initiative and also a lawyer, local lawyer. We have heard a lot of about standards, and standards are important to make investment institutions better, make the local climate more attractive for investors. My question is about the emerging trend, and this is of course an international legal forum, and I wonder if there are any plans or current trends whereby issues of standardization will be treated not only within the Russian domicile, but more globally within Eurasian domicile. And I wonder if there are any plans to expand the geography of these standards. And I believe that this question goes better to you, Sergei, because in terms of news, we haven't heard much in terms of statements on that topic. I wonder if any work is being done on that, in that area. Thank you very much for the question. Russia is a regional moderator for G20 for Mongolia plus CIS countries. So the mission of Russia is to ensure that G20 and FSB standards be implemented further on to other sovereign countries. Our concept, our understanding is that with Belarus, Kazakhstan and other allies, this process of standardization is to be based not on a segregated but on a common platform which is inclusive of the United States, European Union and Asian countries. There's no sense in harmonizing laws inside the Eurasian allies. So we need to go further. We need to be more globally standardized, and this is the overall trend. And because there's a lot of interaction between national central banks, they do a lot to develop their common standards, and even this recent initiative on the local payment system will be involving other neighbor countries. I mentioned Kazakhstan in the context of insurance, of pensions, and they have very interesting approaches where Russia can borrow from them, and to fully involve Crimea in the Russian legislation. We see some standards, Ukrainian standards, have been accepted across the European Union. They've been implemented in Ukraine. So Crimea may have to make a step back, and I don't think it is right. I'm sure we could follow into the steps of our colleagues there. So my answer briefly is that we will not be doing anything that will separate us from the rest of the global world. We need to follow the general trend and harmonize each other, not by moving towards each other, but converging within the framework of one trend.
In conclusion, maybe we can ask each of the panelists to say what may be the strong sides of the Russian enforcement and regulation in the global markets. Let's promote Russia as a market. Alexander, you spoke about marketing, the need to making our position known to the international market players. This debate is going to be presented, it's run live on this website of this forum. So you have this platform. Let's use this as a forum. I think the message that we want to convey to international investors is that Russia's strategic advantage is in the faults and gaps that exist in our legislation. Excuse me, let me interrupt you. Let's talk not just to international, that's foreign investors, but to all of them, including Russians. Let us address all investors. All right. Let me repeat my idea. Ironic as it might be, the biggest advantage of the Russian market is that we can improve as different from developed markets, those transparent and well-regulated ones. This makes them more expensive. The Russian market has lots of faults, but this is an upside. If you enter the Russian market today, you can earn rather more. In the European and American markets, you will be in a more stable situation, but you will be hard driven to find the little pips of advantage. Can the central bank guarantee this within the framework of regulation? Well, the Central Bank of Russia will guarantee the implementation of its functions as described in its charter. We are in a good working relationship with the Russian government. We're together working on the project for creating a financial center in Moscow. So there is quite a lot of future that we can foresee. Like musicians in an orchestra, we're all playing this tune together. Not to repeat myself, and just mentioning that we have good regulation in place, and there seems to be no great difference between institutional and regulatory risks between Russia and other countries. Let me say this. The Russian market is undiscovered. It's undersold, even domestically. The accounts of Russian investors are fewer than 1 million, and just a tenth of them are active in any one month. In Hong Kong, by comparison, more than 2 million accounts are active. Consider the difference in population size. Less than 10% of the Russian population are involved in the stock market. In America, it's over 30%, and other countries are around 20%. In China, just a few single-digit percentage points are involved, but with their large population, that of course it's still a big number of people. Well, the Russian market is undersold to the even to the Russian investors. Pension funds, for instance, are involved in the capitals market to the tune of 1.8%. In South Africa or Brazil, it's 25 to 35%. So Russia has great potential because we're undersold. Professional funds, or foreign ones, know about that, and they see the upside here. It's the Russian investors that need to be informed about that. In 2015, we can expect the completion of the pensions fund reform, not to be confused with pension reform. Anyway, there are now new tax breaks for investment in securities, which are, with the situation now, equalized with the capital gains tax. We hope that it would be done within 1 year. You see, the difference between securities and real estate here is that real estate is hardly ever traded overnight. Securities are. Taxpayers will feel the benefit of all these reforms, not immediately, but rather later, after a tax period expires. So we hope that in 2015 this will be already felt. And this is a message to domestic investors. International investors are aware of the upside already. It's a familiar sort of question. Prosperity has been attracting international money into Russian shares for almost 20 years. And explaining the upsides of the Russian market is what we do all the time. So I agree that the Russian market is underpriced. Russian shares are cheaper than those of other emerging economies, so there is big potential for growth. Why the discount? Many believe that it's because of poor corporate governance and poor investor protection. I would say it's not so. The Russian corporate law protects investors even better than in many Western countries. We have instruments such as the cumulative election of the board of directors, which gives rights even to minority shareholders if they want to increase level of corporate governance. The board of directors cannot dilute capital because of some regulations and guards we have in place. We have better regulated types of deals, etc. The corporate law in Russia is in many ways stronger and better at investor protection than those in other countries. True, we have some gaps and the government is working on improving them and closing the gaps, as we mentioned today already. Still, we see a lot of positive events, positive dynamics. Besides all of that, as we always say, investors should be active in corporate governance, in insisting on improving it, and that's what we do in our fund. We do that aiming to minimize corporate governance risks for our investors. And now, Kirill, it's over to you. I agree with those who spoke before me here, and I'll add this. As this is a legal forum, let me say this. Legal regulation and the legal system is typically a description of de facto relationships in the society, and the capital markets are a sort of mirror that reflects the situation in the economy as such. The recent economic forum here in St. Petersburg had this interesting debate, which came up to this. International investors know that the Russian market has great potential and that it is attractive to investors. But this potential, for reasons of history, possibly, are not quite so well known to investors, domestic, no less than foreign. But regulation is becoming more investor-oriented in Russia. And all the processes that are launched or that were launched some time ago will eventually culminate in an improvement sooner or later. We must work for the future of our country. All right, we are at the stage of conclusions. The climate, let's look outside the window to prove that. The climate is improving. This is an apt illustration of the potential of the Russian market. For myself, I have heard something that supported me in my view that all the participants in the process are prepared to work for the future. And this is an ongoing process. It can never be completed. The financial market never stops changing. Investors come and go, new types of players emerge, so this work will have to be continued. It will be work cut out for us and for our children to come. I want to thank the panelists and those who asked questions from the floor. I want to wish all of you interesting and fruitful discussions in the remaining time of this legal forum on behalf of Gazpombank. I want to invite you to the business breakfast tomorrow, where we will continue this debate in a broader framework, discussing the place of Russia in the changing world. Thank you. This will complete our session.